Sorry, there was one program that consumed time.
Admission, madam. Give all the memos. If your pardon to make one mention out of the list, madam, the lordship for this inquiry.
Pass on the memo.
No, madam, out of the list.
Out of the list or within the list?
Tell us in the list.
Say that. Out of the list means something which is not in the list.
My lords. Item number 36, my lords. Others, on the last occasion, I had served copies of the petitions on all the respondents, except of municipal corporation members. When I went to serve them a notice, they said that you issue notice because we have many advocates appearing for municipal corporation. What I humbly pray, my lords, I had inadvertently, my lords, missed to file requisites for issuing notice.
File it.
Today, you
File the requisites today.
Yes, my lords, today. I just need.
Please do it.
My lords, only on respondent number.
I know.
My lords, read appeal number 831.
Oh, please do it. Go and file the requisites.
item 36.
36, my lords.
Remember, just remind us when it is called.
My lords.
Item 51.
Municipal corporation. Repealers
Go
today.
to the other side.
Office to proceed.
Statement.
First, let him deposit. Let him deposit.
No, that takes to, let's in case it is deposited, then office to proceed to issue notice and
51, who is
fix a date
appealing?
in there.
For the state, and there is a private respondent also. He is not appearing. Petitioner does not want to raise the matter.
No interim order?
No matter.
Yes, call the list.
Item number 1.
This is a matter relating to a bid process of a sand soil agreement. The impugned order is at Annexure 9, page 84. That would be PDF page number 179. We have
9, I am not getting it, right? 8 and then 10. Oh, yes, 8 and 9 is one. Correct. No, not
page
this.
84, Annexure 9, PDF page 179.
Yes. This is a letter of 5/6/24.
My lords.
Yeah.
Here they have rejected my application to grant it in favor of the petitioner on the ground that OMMC rules 2023 have come in place.
Correct.
So the background, my lords, here would be, if your lordship would see the list of dates we have given at flag 10, that would be PDF page 205.
Yes.
Here, the point we are trying to make out here is, if your lordship would see, and I'll quickly run through the list of dates. Tender was called on 8/1/2018. Serial number 2. The bids were opened. Out of 4 bidders, Sukhanti Sahu was declared a highest bidder, and one Ranjan Kumar Patnaik and the petitioner being declared as H2 and H3 respectively.
Correct.
The lease was not finalized in favor of Sukhanti Sahu as she was found to be a defaulter, and thereby ineligible for grant of quarry lease under 49 of
Then
the
S2 was offered.
H2 was offered.
Correct. Then
H2
accepted it.
accepted it. Lease was granted.
executed. Then
Lease was granted for 5 years. Serial number 3 is important. For 5 years in his favor.
correct.
Then H2's solvency came into dispute. If your lordship wants on the list of dates.
Yes. Then
So his solvency collector cancelled. Writ petition he succeeded.
correct.
Now writ petition he succeeded, and I was arrayed as a OP in that writ petition. I carried the matter before the Honorable Supreme Court.
Correct.
That would
Not
be
for the division rate.
no division bench only
Then
allowed. Supreme Court 3/3/2023 decided the matter in my favor.
set aside the order,
Set aside the order. That
What
would
it
be
says?
Annexure 4, page 36.
holding that the cancellation of his offer was correct.
His offer was incorrect. Collector's order rejecting the bid on the ground of lack of
Cancellation of his offer was upheld.
upheld.
That is
On
what
the-
I'm saying.
Yes, Manoj. I'm sorry, Manoj. That's what solvency certificate was found to be
Then
not
what happened?
acceptable. And that order came about on 3/3/2020.
Yes, I've seen that.
OMMC rules, which we have annexed, my lords, that was gazetted on 24/4/2020.
Okay.
So the point that we are trying to make out is you
That
cannot
was if the event is of a prior
priority
in time,
to
then whether the retrospective effect can be given to a act.
a rule. And my rights got crystallized on the date of the order of the Honorable Supreme.
Correct.
So we have given that the OMC rules which came are at page 5 of that.
Now, what is the problem now?
They are not granting me I'm the next bidder. I should be given the SIRA. They're not giving it to me.
Show us that it has a retrospective operation.
And the rule itself I have given at page 5. That is page
That's the only point.
209 PTS.
At the Begras or some cases.
Yes, those judgments I have got.
Begra.
These rules have to be unless specified. So it is gazetted that it would come into effect on the date of notification.
It's the ordinary principle of law is that every new enactment or either substantive law or a subordinate legislation is always considered to be prospective in nature, unless intended by the legislature to operate retrospectively
I'm grateful.
or retroactively.
Well, I'm grateful. I have come with those judgments, but this is the point.
It's a pure question of law.
You to file an affidavit to them.
Pure question of, I know that you will ask for affidavit, that's why I uttered a word, pure question of law. These facts are undisputed.
Well, so far the applicability of this rule of 2000.
That's a pure question of law. Show us that retrospective or prospective in nature.
Now, my lord,
If it is retrospective in operation, no difficulty. No difficulty. He does not have any right. If it is prospective in nature, if the right gets crystallized prior to coming in force of the rules, then whether that right can be taken away.
well, they have raised another question of blood page 6. That's a kind of.
Don't forget about it. Now, this is the only question of law which is involved.
Page 6 here. That's a kind of a glance. They're taking it because of rule 27(9). They say under rule 27(9) they have got a right.
That's the repeal and saving clause. Or what is that?
No, that
No.
says that the second highest bidder has to be offered
Okay. So that's the in order of
in
precedence.
price.
Well, there is a difference here. So, subject to lots of appreciation.
First thing is whether this rule applies or not. Then which rule applies?
2016 rule applies. my lord.
If it 2016 rule applies, then in that event, if the highest bidder did not come forward, second highest bidder was declared incapacitated to enter into a contract, then the third highest bidder, why not?
My lord. That
I'll
proviso is.
just interrupt me, but if my friend says the 2016 rule applies, then Mohinder Singh Gill will come because impugned order at Annexure 9, page 84,
They have applied the new law.
23 rule.
So then Mahinda Singh Gill will come. If your authority has taken a particular point, then you cannot take a different point either by way of an affidavit or at the bar.
So far, the scheme of the statute in 2016 rule is functional, my lord. Subject to lots of applications.
But you have not taken, your authority has not taken.
84. Page
Your authority has referred only 2023 rules. Can it be justified?
As per aforementioned clarification, following the implementation of OMMC Amendment Rules 2023, the settlement of any SIRS source, so and so, over area of so and so,
Please
Shall be
go
done through-
read the law, come argue on a proposition of law. We can't put you on surprise. He has taken that plea. Look at the judgment of Mahinda Singh Gill, whether you can dilute the judgment, come,
My lord.
or tell me whether 2023 rules has a retrospective operation. These are the two principles.
So, my lord.
We are fixing on Friday, small matter.
Can it be founded?
Why? Invest an evening in your chamber. Read the law. That's the only thing. You'll have to read the law.
Right.
The
Remind-
pivotal issue involved in the instant
let them not settle this source because they are on the
Miller, we will not put it on auction, Miller.
he has not.
may not auction.
We have not
He has not.
started the
He has
process.
not invited the application. That will
They
take
have
time.
not because today they have not. But in case they do it,
Do it even tomorrow. They have to give a time for making applications.
I'll
So
come
that
back.
will be another 15 days or a 1 month. No difficult. You are fixing on Friday.
Grateful.
Item number 2.
Item number 2, I am in the VC, my lord. In this case, the state is supposed to file an affidavit.
With the collector and ADMs, they have been transferred, Your Lordship. I've spoken to the ADM who has taken charge. If you come on Friday, Thursday or Friday, Your Lordship, I'll file get the details in. We'll check in with the office and the records and let us know, Your Lordship. Both of them are new, Your Lordship.
Yes. Extension of time to file.
My lord. Your lordship, your lordship, please.
Yes. Monday.
Monday.
Counter affidavit within by Friday.
My obliged.
Item number 3.
Where I filed an application.
IMFL. IMFL.
Yes, my lord. It is an on-shop law.
Whenever
That's
you were appearing, I thought IMFL.
No, sometimes CS also.
Yes, yes. It's fine. Country liquor.
OS
Out
outside.
still liquor. That is manufactured out of Mawa flour.
Okay.
It is abundantly available
It's
in
all
market.
related matter.
Yes, Lordship.
You have not come out of the zone of.
No. I have,
Yes.
but Lordship's roster is
Uh,
the Lordship's roster is excise, that's why it is.
yes, what is this?
No, here your Lordships allowed me that to deposit 50% of the demand. But no, there is some difficulties will not, that's why I filed an application that maybe another 7 days I required to.
We will not pass any order.
The
Come
Lordship.
with the money.
Lordship.
Show us the color of money.
Yes, Lordship. I'll come. Lordship will fix it to 13 or 14.
Yes, no difficulty. No.
14.
14th. Item number 4.
The petition is challenging the limit to the 180 ml.
Oh.
I have
Yes, but
Why don't you take a decision, sir?
policy is under challenge.
The policy, I do not know. There must be a reasonableness in the policy. You permit them to sell of a large quantity. You are not permitting them to sell to us the smaller quantity. What is the rationale in between that?
even instance, a smaller quantity.
Are you preventing them from selling, say, 1 liter, 2 liter, or 3 liter bottle?
That has been fixed only in respect of the restaurants, bar and restaurants. So far as other foreign liquor on shops are concerned, they have
Either
been
you
allowed.
stop, I tell you very frankly, either you take a policy that there will not be any sale of a foreign or a country liquor throughout the state. Fair enough. No problem. Take a policy, stop it completely. But if you say, no, you go on selling because it's a revenue generation which we cannot compromise, then how can you make a distinction that you cannot sell what is this? 60 ml, 90
ml,
ml,
90,
or
60,
100
90,
ml.
180. They have been prohibited to sell 60, 80 and
See, I have
60,
seen 60, 90 and 180.
180 so
He
far
has
as
challenged that.
these bar and restaurants are concerned. So other liquor shops, online shops, they have been allowed.
Online shop, I do not know what is the distinction between an online shop and an offline shop. The only difference is that one can consume there, sitting there, and one cannot consume in the premises. He has to take.
That is on shop and off shop.
That is what I'm
not
saying.
online. I'm sorry. That is on shop and off shop.
Definitely.
Yes.
This is what is the only. The consumption you are not avoiding. Either the consumption at home or a consumption at a site. What is the difference? They are consuming.
Intelligible differential.
That is what intelligible difference is. You are creating a class within a class. Tell us, because unnecessarily 1,000 matters are pending before us.
Batch of cases.
What is the rationale in it? We are with closed eyes permitting 180 milliliter
Well,
cells.
why don't you pick up one case, file counter? Pick up one case.
And in some cases, to be honest, the superintendent, they have filed the superintendent. But once the policy is under challenge, it is the state, the department has to file. So we have.
Why don't you file in one
Yes.
matter? Let us decide.
Anyhow, you are preparing.
Yes.
They will come forward to say with regard to fact.
So that policy, they will have to justify why.
Legal issue, you are preparing. You are addressing.
tag this matter to that batch so that I can file.
We are doing so, sir. That is why we are requesting you, because we have seen that more than nearly 1,000 matters of this nature is pending.
Coming up.
So there must be an end to pick up one matter, whatever, tell us, we want to hear and finish it off. This way or that way, no problem.
Tag this matter.
You file affidavit here so that we will take it as a first matter.
We'll file affidavit in this particular case, your lordship.
180 ml affidavits within 3 weeks. Rejoinder, if any, within a week. Matter to appear after 4 weeks. Give a date, fix that day. You'll hear.
2nd September. Item 5.
187.
Secretary, may I pay one time allowed my to see the judgment also. I pay one.
PIL matter, they are praying for adding the coaches in a train.
What?
They are praying, it is a file a public inter litigation, praying they are in that railway coaches.
Oh.
Coach, they should be added in the train. If technically,
Coaches means additional coaches.
yes.
That's a bogie.
Bogie to be added.
Means additional.
Additional.
Is
The
it
odd
public to
man,
decide that, what should be the additional coaches, or what should be the number of the coaches, or a bogie is to be attached with the engine?
We are called upon.
Whether the engine has a capacity to
file or not.
bear the load of 15 coaches or 20 coaches.
Yes, ma'am. That is the cost of Kolasa passenger is going on 12 coaches. I need to attach additional coaches.
That is the public will decide that how many coaches can be attached. They think that they will give the policy decision to the railways how to operate the railway system.
You must be reminded of one incident which took place on Mahanadi bridge. A bus was coming from Kendrapada. Casualties?
Yes, sir.
What would you say about that? Tire burst. You would wish to double decker with the same wheels?
This was the one application is pending.
So who will take that responsibility? God forbid, any casualty.
We'll put a clause there that in any event in future anything happens, he will give an undertaking that he will be held responsible for that. Sir, what kind of a public interest litigation is coming? Whether an additional coach or a bogie will be attached to a particular train or not, it is within the exclusive domain of the railway administration. That depends upon multiple factors. Multiple factors. Capacity of the engine to carry those coaches, the load factors, whether the track has the track over which it runs has a capacity to withhold or withstand those.
The local train
is a
very crowded is there. That is
crowd is always there. Commuters you cannot avoid. That is the railway administration, whether they want to give another train separate. Why the additional coaches or the bogies?
Sleepers.
Absolutely, sir.
Sleepers.
Sleeper and the number of engines, its capacity is to bear or carry say 10 coaches. How can we attach 12 coaches? If it does not run fast as is now, again you will come.
You take a decision as per law.
No. Create another.
You have chosen a bad person for this.
One application is.
I am definitely against the principle of passing a direction to consider representation and dispose of. No, sir. If you have a right, your right would be decided here and now. If you don't, the doors are there. Show us the right, how far a citizen can interfere in this, in a public interest litigation.
Just one is after I will. It become one.
Keeping it hold.
Unnecessary. There will no this kind of affair.
Has to be made clear in the budget.
Absolutely. Absolutely.
That more filter down.
Oh, no, definitely, this confident.
But this one. Some.
No, sir.
Permit to withdraw.
You don't want dismissal.
Withdraw.
Yes, permit to withdraw. What do you say?
Yes, my lord. Lordship.
Yes, withdraw. Give memo.
But I thanks to my lord that one observation my lord has observed, the same instruction we have received. Engine capacity, distance of the station, all should be taken into consideration for
Not only engines, sir, sleepers also.
sleepers also. Yes.
Sleepers and the track.
Track.
That
Yes.
is also most important.
Yes, also.
No, feasibility, everything, because additional coaches may impede the speed also. So time.
They are also saying,
timing
they
is
are also saying so. They control the speed. They are, it is create another problem. Yes.
Yes, withdraw.
Item number 6.
Memo.
Yes, memo is filing.
After 2 weeks.
Obule.
After 2 weeks.
Why?
Notice has not been issued.
Preemptive.
Fresh matter.
What could be?
Why it is no? 2 orders have been passed.
No, this is a fresh matter. Man.
Fresh, what I am looking at, 6 I am looking at.
6.
2 orders have been passed. One is 8-7.
I was asked to.
You asked for a time.
No, I asked.
Then again you asked for a time.
I asked for a time because I applied for some documents and the earlier tenders.
Sir, you are a senior advocate. You know that when a client comes and the drafting is to be done, just ensure that all the documents are there. How can you draft a petition without documents, important documents being produced?
That you should not agree with that. I have asked for every documents. Lordship kindly grant me at least 1.5 weeks for a time.
This is really occupying a little space which we have.
No, I take the onus, man. I take the onus upon my.
2 weeks.
Grateful.
Item number 7.
Is a single word or 2 words? The word you uttered is a single word or 2 words?
I take the onus on myself.
No, the word you utter is a single word or 2 words?
Grateful. Grateful.
Single or 2 words?
No,
Is it
single word.
Is it a grateful?
Not
Grateful.
Man,
I just wanted to know.
if it comes this side, man, I don't know. But
So you mean 2 words?
as long as the address to the other side, man, it's only a single word. Great.
7.
That's the petitioner has filed this application by way of PIA.
7.
PIA, the illegal and arbitrary actions the opposite parties, more especially opposite party number 3, Tahsildar Sukinda. So in compelled attitude to demolish.
Can you repeat?
Lordship, the petitioner has filed this writ application by way of PIH, assigning the illegal and arbitrary action of the opposite parties, more especially opposite party number 3, Tahsildar Sukinda. Showing casual attitude to demolish the structure illegally constructed in the government land. Even after initiating a notice for demolition under section 4 and 6 of OPL Act, not proceeding further to complete the process of demolition.
Order has been passed for demolition.
Yes, Your Honor.
You say the proceeding was initiated. Has no order for demolition passed? Or not passed?
Not passed. Not passed.
Whether they not passed, then how can we direct them to demolish? There must be an order.
Sorry, my lord. Passed.
Mike is here, right side. Oh.
Sorry.
So they have to complete the proceeding. Yes, what are you doing?
Kindly see that.
And for public interest litigation to complete the proceeding. Just imagine.
Mullah, there is an interim order by this honorable court that no coercive action is to be taken. And
Oh, there is no coercive means there should not be any order for their removal.
Yes.
But up to the stage of passing an order for removal, there is no fetter.
Mullah, we have passed an order. My lord, we see.
Oh, I am asking us, he said no order of demolition has been passed.
A date was fixed for demolition, in fact. Lord, we see
Okay.
Annex 3. A date was fixed, but my lord, on that.
Now, madam, what to do? You go there. There is already a prohibitory order. So unless that order is vacated, you can't. Oof. They have gone to the appellate authority.
Yes, my lord. They have also prepared a complete
Judgment.
that is pending.
We can't. When we are disposing of them, we can't keep it.
That's
There's a public interest litigation at the behest of a public spirited person seeking a judgment upon the respondent number or opposite party number 3. The second party number 3. To initiate a proceeding for removal of the enclosures and demolition of the structures constructed by them over the government land. So,
8, tender matters where your lawsuit continue. In 18,300, I am filing it in the course of the day. Other two cases that is 18,300 of 2025, I am filing in course of the day. 1 and 2, my lord, I will
18300.
1. Yes, that I am filing in course of the day, my lord, the counter.
And for P number 1, they made a cabinet secretary as a party. There is no need to include the cabinet secretary as a party. If they dispute within state.
3 days. And the last one, my lord, was posted to 10th of August, I think, if I am correct. But I will file it within a week also. Last one. This 18,300, I am filing it in course of the day. And if the point almost involved is they have challenged different causes of the tender. All will be
you can't
completed.
go that in this you will file within 3 days, in that 7 days. We are not, we are giving you a uniform time within which you complete the filings and all the.
Ma'am.
You are for?
I am for the opposite party number 4 and 5, the corporation.
Give your, the name so that there may be a different opposite parties, your number may be different. You are appearing for who?
I am appearing for the Orissa State Civil Supply Corporation.
Yes, the council appearing for the Orissa State Civil Supply Corporation.
Yes, limited.
Limited.
Yes.
But it's, that there's the time to file the counter affidavit will be extended. As his client intend to.
Mention one matter, your lordship will take to that matter. It was taken up on.
Ask for another time to file counter.
No, my lord.
Don't take risk.
No, my lord. It has been listed on 25/7/2025. Your lordship is directed to list along with this matter today.
That reading is complete.
No, my lord. This is a fresh
You
matter.
wanted a disposal or you wanted a.
I want disposal.
That's all. So let him come in this for, don't create confusion. We will say it will abide with the result of those.
I have taken some other points. For that reason, your lordship has kept.
The copy has been given on fast only.
No. I am not saying that. It is directed to list. It is in judicial order. For that reason, I am.
Item 9.
It is not listed today also.
Please, your lordship. Relates to the non-payment of dues arising out of a contract between the petitioner and the Department of Women and Child Welfare, Government of Orissa, my lord, for supply of chairs, tables, and water filters to ICDS Integrated Child Development Service Projects in Gonjan district, my lord. The lordship finds the page 17, that is the bid document. The bid was through GEM.
Yes.
Page 17, my lord. Lordship, department name, Women and Child Development Department.
Who is appearing?
My lord, in this matter, I have received instruction, my lord. The fact is that, my lord, a part
You don't
of.
have money.
My lord,
Fact is that you don't have money.
no, that is not that. My lord, you have received part payment, my lord. Now what happens, my lord?
What about the
Challenging,
part?
my lord, challenging this procurement notification, my lord. One topic is number 1758 of 25 is pending before this honorable court. All the collectors have made petition. That is an interim order, my lord.
What? Not to release any payment.
My lord,
What is the nature of the interim order? Not to make any payments. If not work is done by them, there is no dispute. So you will not make the payment.
now, my lord, there is an interim order, not
What is the, not to?
not to proceed with that.
What, not to proceed means what?
Not to proceed with that tender, Miller. Now, as the
He is
work
not concerned with the tender.
Yes,
I have already completed.
Already completed the work and everything has been
and
done.
submitting. As they have completed the work, now the department has written a letter to the government, Miller, to sanction that remaining part of the fund so that it can
Sir,
be
when I read first, my reaction was this. No money. You say, no, there is no problem. Money is there. Now you say that you have approached the government for providing a part. That means you have no money.
money is not with the with the DSW.
You are representing state or a DSW? Tell,
Now state has to.
you are representing home for home.
State. State.
How you are representing this DSW?
I received the instruction from the DSW that they have.
Why you are representing if you are a state?
Disputing the losses 7 series.
No.
This tax invoice.
No, I am not disputing. We are not disputing.
Communications.
No.
We are not disputing.
The difficulty is that both the state and DSW are represented by a common council. And the argument is that the state is not providing the money. How you are representing both when there is a conflict?
But here,
one is not providing you money, then there is something. Remarks is that.
Millet, I may be pardoned, Millet. So I do not convince you a lot.
I can understand.
Millet, the information I have received from the government, Millet, they are going to release it within a month, Millet. Within a month, they are going to release the money.
Release the money immediately within 3 days. Well, since when it is due?
Since April, my lord. Work was completed in April, my lord.
4 weeks time. 4 weeks time.
3 days.
Just one.
Is directed to take an update. It's in view of the. Here, yes, 8 days, 10 days.
Yes.
More.
Item number 10. Hi, sir. Fine. Item number 10.
That's not the
Yes.
So just now the handicap was counter lordship there's just now.
Counter.
Lordship by the temple administration.
There is no counter.
No, yes. They are also.
The court.
Madam,
You're filing in the court.
that meant yesterday's had ailments that would not have been conflict. I have already served just both of them.
Just now.
Money.
Yeah, also.
I have this.
It's not a period.
Let's
We are amending it. We are permitting it to go for 60, 90 and then 10. All three. Nothing more?
No, 90 is enough.
1 liter, 2 liter.
No, 2 liter is not permitted in India. 750. I
Not
think
permitted in India.
India.
2 liter, 4 liter, 5 liter.
Oh, 5 liter is sometimes available.
It is in the airport.
Airport only.
It is available in the airport, Lord. Not by the corporation.
Goa.
That is only, sir, the Scotch. Scotch is 4 liter, 5 liters.
Yes. Next.
12 also same. 12 also same. There are 2 cases. The main case your lordship has reflected in the order. That case counter is required to be filed. So that all cases.
Sir, in one matter, we have requested to file a counter so that at least let us dispose of. More than 1,000 matters are here, 180, 181.
Only there is any rationality in
Item 10, incremental continuous, item 10, let's see. 10, no, item 10.
Oh, yes.
Well, item 11 12. 11 and 12.
Yes, yes.
Item 13. I've connected the
Item 13, my lord.
connected.
My lords, here, the petitioner is the director of petitioners or the directors of Orissa Cooperative Housing Society. Now, my lords, the general manager of the Cooperative Society floats a tender which is wholly without jurisdiction. So accordingly, we make a complaint before the
Director of the Housing Cooperative Society.
society. It's a cooperative society. We made a representation to the registrar saying that the manager has no powers to float this tender because the managing committee has to do it.
Nature of the tender.
The tender is, my lords, for Annex 3, engineering, procurement and construction, contract, supply, installation, testing and commissioning of firefighting system for Dholi Heights apartment complex, Tamando, Bhubaneswar.
Is it a statutory corporation or
No, my lord, it's a cooperative society, my lord. My lord, we are not asking your lordships to interfere with the affairs of the cooperative society. We made a representation to the registrar because in the meantime there was a challenge to the.
Now, I think under the Cooperative Societies Act.
Yes, sir.
Power of the registrar to adjudicate any kind of disputes.
My lord.
So I think we have to approach to a
We have
registrar.
approached. That is exactly a grievance.
Previously, in 2010, it was section 89 or 93.
That is exactly what we are asking your lordships. My lords, Annexure 4 at page 32, we have approached the registrar, raising all our grievances. He is not taking any action in the matter. So within a time bound period, if he, because this is a tender month. My lord.
You have to give a notice who is appearing.
Notice is to be issued to OP number 4 and 5.
Registrar you can't represent or can you represent registrar?
Yes, my lord.
Registrar
They are
OP
part of the state government.
My lord, we are representing 1, 2, 3 wheeler.
3 is the registrar.
Yes. So what are you doing when such an issue is raised? When the director has come forward and say that we did never issued the tender, how can a manager
Manager in charge.
Nominated, appointed or elected?
Appointed. And can be only done by the managing committee. As per the bylaws, the managing committee of the society can do.
What are you doing? You are the only authority.
Take instruction.
You are passing an order, communicate that order, and then thereafter take instruction. We are disposing of the writ petition, issuing the writ of mandamus, and till then thereafter to give you instruction. Where is the provision of the cooperative here? This section.
Section 61.
60?
67. 68.
Because in the West Bengal Cooperative Societies Act, it was 93 or something.
Yes, sir. Here it is 68.
Settlement of dispute.
Settlement of disputes.
Yes. The instant this petition
Process may be carried out, but the tender cannot be finalized.
I have a strong
submission are the same regarding rejection of the refund application of the petitioner notes. In this three matters, my lord, I require your lordship's sympathy and empathy of Mr. Mishra. Because of the serious health condition.
You have this one more word.
Pardon?
You have this one more word.
Yes, sir.
Empathy, sympathy, you have seen. Compassion to be shown to you.
And the resultant would be the compassion of your lordship.
Yes.
It falls like a gentle rain from the heavens,
Yes,
my lord.
that's Mr. Area, Mr. Mishra.
Mr. Mishra, my lord, the empathy of Mr. Mishra. What has happened in this case, my lord? May I just take your lordship to the medical report straight away? I've given the medical report as an additional affidavit in the first case and annexures in the other two cases. This, if your lordship would kindly take up the medical reports.
That your client is suffering.
No, but the husband of the proprietress, my lord, he was detected with, it developed like a small spot in the tongue. Then it was carcinoma. Metastasis, my lord, of the bones as well as the other parts of the, and he's still under treatment. After radiation, he's still under treatment. No? I've given the medical report. And for these reasons, my lord, he was unable to attend. In the first case, my lord, the proceeding was concluded, my lord, 1 day ahead of the show cause. Then I have a semblance of case. Because the personal hearing was fixed on 26th of February. The orders were passed on 25th. Sorry, no? Essentially, all the three orders were ex parte. The reasons I can only say for the first case, my lord, the reasons are the order is 1 day prior to the date of personal hearing. But ultimately, my lord, I'd be obliged if your lordship would kindly give another chance to the petitioner to appear before the authorities, produce his papers. Because these, my lord, these refunds, my lord, arise out of an supply to made to an SEZ, my lords. And if he gets some amount of refund, my lord, it can be adjusted against other pending, my lord, demands, so far as the SGST and CGST parts are concerned, which have already been confirmed. It's an appeal. So that will be my only humble prayer, subject to your lordship's kind consideration.
Your Lordship, I'm so sorry, but this case may not be Your Lordship for sympathy.
No,
Your Lordship, let me.
There are demands. I do not say.
Let me.
And I'll not take note. I'll not take this. I'll not take note. I appreciate my learned friend's anxiety, my lords. And it has been also reflected, my lord, there are demands outstanding so far as CGST and SGST is concerned. These refunds arise out of the IGST regarding supply made to an SEZ. My humble contention, Lord, let it be quantified.
Well,
The order was passed prior to,
Your Lordship,
that is,
Your Lordship, that is admitted fact.
the additional affidavit enclosing medical code
Your Lordship,
that shows serious health issues.
that is wrong. That is not, that may not be accepted. Why I am going, I'm showing. Because every month he was doing business continuously.
I'm talking about the
He has
husband of
filed
the
a-
proprietrors.
let me-
I'm talking about the husband
You
of
have
the
completed, let me. She has continued the business. She has filed her regular return. She has participated in the assessment proceeding, adjudication proceeding. Against the adjudication order, she has filed the appeal. And Your Lordship, all along she has participated. And this is the refund claim pursuant to the return. The return has subsequently scrutinized. Audit has been conducted. Adjudication proceeding has been drawn. Against that adjudication order, he has filed appeal. Appellate order is there. Then it became infructuous. This is the initial stage. So if this has been filed in 2023, this is the impugned order of 2023. If this writ petition could have been filed in 2023, then the subsequent action could not have been done. Then Your Lordship it could have been set aside. Your Lordship. Malik.
If you consider this refund application, then if refund flows,
Your Lordship.
that could be adjusted towards his demands subsequently raised or in the.
How can it be, Your Lordship? How can it be when the return has been subjected to scrutiny and audit and that has been conducted? How the initial refund which has been flown from the return will be adjudicated again? Because everything has already been adjudicated. Your Lordship may kindly turn to page, only one page, one line, Your Lordship. In the first read, page 37. These are the evidences so far the first matter. Every matter, Your Lordship, there are file, Your Lordship, page 37. And why prior to one day the officer has done the mistake, but why that mistake has been committed, Your Lordship may kindly look into. Page 37. The impugned order, the annexure of the impugned order. The second paragraph, in response to query number 2, Your Lordship got it? In response to query number 2, taxpayer replied that so-and-so supplier declared GSTR, but due to lack of knowledge, the taxpayer has not shown the above reply in outward supplies in GSTR 3B. On further verification of GSTR return April 18-19, it is revealed the instant taxpayer has filed but has not discharged the tax liability. It is clearly a case of understatement of liability and abstract proceeding under 73. Accordingly, adjudication order in DRC 07 in the instant case has been passed by reference number so-and-so, Your Lordship, I have given. And as a penalty of rupees so-and-so, being aggrieved with the demand order in the instant taxpayer preferred first appeal and the demand raised LPO has been confirmed in the first appellate authority. But till date, the above amount has not been paid the taxpayer. Subsequent to this, audit has been conducted and audit assessment has been completed. In some cases, in 2020-21, against the assessment order, he has come to this Honorable High Court, and this Honorable High Court restored the matter in the third matter, and again on restoration, the adjudication has been completed. So these are infructuous, Your Lordship, because these are the initial stage of report. So whatever this is the impugned order of 2023, and it is appealable.
So ultimately, the authority is after the audit and everything. No question of any refund.
Mm.
And further demand is raised.
Demand has been raised. So if in
Under the
2023,
under the-
subsequent assessment could not have been
Under
completed,
the
and this
CG,
has been considered in that.
that is, my lord, your lordship, to see the act in which the demand has been made. My refund claims were on IGST, supplies made to an SEZ unit. The demands are raised not for the CGST and SGST portion. So my learned friend says, no, my only humble friend, Lord, if I produce my papers.
That jurisdictional aspect has further been considered.
Pardon?
That jurisdictional aspect that the supplies made to SEZ.
That is not, your lordship may see the last paragraph.
Falling within the ambit of IGST. That was
Not considered. No. Your lordship may see, my lord, the last paragraph. As the taxpayer has not.
Your returns were.
My lords, my application, my lord, your lordship.
Returns.
My lords.
Showed this aspect.
Your lordship may kindly see that my reply to the show cause at page 31.
2020,
31.
13 of judgments your lordship has passed. This is appealable.
There are cases and cases.
After
Lordship may
2
kindly see
years,
page
your
31,
lordship,
please.
without any reason.
Your lordship may kindly see page 31. My reply, my lord. In the first case. First case. Page 31. Sorry, please. Page 31 and extra 4 belongs. I have given the reasons that these are all supplies made to SEZ minerals. And minerals, these things
Due to lack of knowledge.
no, that is what has been pleaded. And now the unit is virtually closed because of the series of
Due to lack of knowledge, these are entered by.
SEZ supply in the outward suppliers, taxable supplies, other than zero rated, nil rated, and or exempted in GSTR 3B, but we have disclosed the same in GSTR 1. Due to wrong entry in the taxable value instead of invoice value by the SEZ authority in case of invoice that is GSTR 59.
Your please assessing authority after noticing this error or wrong whatever you have admitted, you should have put it right.
He should have put it right. All that I'm praying, the Lord, is just give me a chance of hearing, go through my papers, and after that, if you find that I'm not eligible for any refund or IGST, well, the matter is closed. But if at all some refund is allowed, my lord, this would be adjusted against the other demands, my lord. And unfortunately, my lord, if your lordship would see, come to page 29, my lord. Page 29, your lordship would see.
This refund is around.
This refund is not very substantial. But three cases put together would be around 30 to 40 lakhs. But at least I'll get some respite of that 30 to 40 lakhs being adjusted against the total demand.
Adjustment of.
Manage. They need not give it to me. They let them adjust it. No, it will abide by the final result of the assessment of the appeal proceeding.
It will be an example, your lordship. It is 2023 order. Your lordship never accepted that down, your lordship. And your lordship, so far as the delay is concerned, it is 2 years delay, more than 2 years delay. And your lordship has considered many judgments. Your lordship has in the meantime has passed.
I've tried, my lord. I'm not, my lord.
So
This is not an appeal. This is not a question of an appeal. This is not a question of an appeal.
And so far as your lordship, so far as the period, your lordship, every month she has done the action.
I have not done it by chartered accountant.
How it will be done by your chartered accountant, na? You will not do yourself.
Your lordship make only
the challenge you will do by your chartered accountant. So I'm sorry, your lordship, I'm so sorry.
Your lordship may just
this type of your lordship, because
then in the first case, your lordship would see, my lord, personal hearing is fixed on 26th of February 2023. And the page 29. You are directed to appear. Page 29.
Accepted. I have already accepted.
So at least that.
I have already accepted. This is the part. It could have been challenged in 2000.
On that score, my lord, this has to go. If my learned friend is not, my lord, so much cognizant about my health conditions of my husband, and I don't think anything more serious can happen because I have personal experience facing all this.
I could have been silent if this challenge was in 2023. Your lordship.
Yes, sir. He has faced
your lordship.
And I think, and that is the reason why you chose the word empathy, my lords. And I expected that empathy from you.
After getting all these documents, your lordship at the beginning.
And your lordship would see 26.
the fallout of this particular order. Had this order be not there, you would not have taken.
Exactly, Your Lordship. Because of all these documents, I could not accept that.
The foundation goes, then what will happen?
So these, my lord, your lordship would appreciate, these, my lord, orders are passed because of a wrong entry on my part. So if at all I appreciate, my lord, and this has been converted to from a completely tax-free.
Why you did not count for one?
No, these are, my lord, these are the conditions.
Challenge this approval for 2 years.
No, my lord, that this, your lordship, that is why, my lord, I beseech you. Lord, I beseech your lordship.
Then challenge all fallout the subsequent actions.
True, my lord. Your lordship.
Not challenge those actions.
My lord, I bow down to your lordship kindly.
Challenge those actions.
And 1919, it is for the subsequent year 1920. The next
your lordship.
Again, your lordship, in the third read, your lordship will find read petition have been filed before this honorable court against the adjudication order. And after that, that has been restored to the first appellate authority. And first appellate authority has passed your lordship. So every year they have participated. Not even non-participation, the orders have been passed. So how these are going to be entertained? Your lordship.
They are challenging a basic foundational
Subsequent order.
No.
Foundational law.
No, not foundational.
Rejection of the refund, my lord.
Your lordship. Your lordship.
The proceeding which sprung from that particular order, rejecting their application for refund.
My lord.
No, your lordship, what happens? The refund is to be flown from the return. These are not any refund.
Probably you would not get what is coming in from us.
My lord.
Suppose if that proceeding remained pending, these proceeding would not have been proceeded with, or this proceeding would not have gone through.
In the past year, the proceeding has completed prior to this.
This order which is challenging here,
Your lordship.
that page,
Is your lordship page 23.
26 and 37.
Your lordship.
Just imagine
Your lordship.
that this order is not passed as on this date.
Your lordship.
Authorities is still hearing the imagine.
Your lordship.
I'm not saying
Your lordship.
what is the reality.
Your lordship.
I'm saying imagine. Suppose this order is not there and proceeding is pending. Then whether this action could have been taken by the authorities.
Yes. Yes.
Independent of that.
Independent.
Are you sure?
Your lordship, these only 1 minute, your lordship. This order has been passed pursuant to the refund application filed pursuant to the return. Those returns have been adjudicated by way of adjudication order before passing of this order. When the returns have been adjudicated by scrutinizing the return, and there is a demand of mismatch, so these refunds are
probably you are not getting where I am heading.
Your lordship, I'm sorry.
Probably because you are thinking in one side.
Your lordship.
Think in neutral. I am asking on the basis of a return. There must be some basis to claim a refund. There must be an adjudication.
Your lordship.
He claims that the refund proceeding should be initiated. I want a refund.
Yeah.
Because there was certain mistake or whatever that has been committed by him. Is it that as well? Now this refund proceeding is still continuing. You are saying that you have processed the return which he filed subsequently.
Audit has been conducted.
Audit conducted, whatever you have found that there is a value. That means if you do this exercise, then virtually it would foreclose the door of the refund proceeding.
Yes.
Automatically that refund proceeding would become non-est.
Yes. Yes.
First and foremost thing is, can that be done to nullify or frustrate the proceeding?
Can it be done?
To frustrate a pending proceeding for refund?
the appellate authority,
Mm.
it seems,
Mm.
even enforce the order of proper officer
Mm.
or assessing officer for
Mm.
that reason. I think taken cognizance of his explanation which is given in that paper application that he committed some human error,
Your Lordship.
I can say that be said so many words.
Your Lordship.
But when mistake is admitted, is it not incumbent upon the assessing authority to deal with that and says
I concede. I admit everything. I admit everything. If this challenge was in 2023, if this challenge was in 2023, then your Lordship it could have.
Trying to figure out something else.
Your Lordship, I have bowed down.
Because we can't exercise the advisory jurisdiction in a law. We are simply putting a question to you to get an answer. That would be a lead for him to do.
Your Lordship, only my submission that these are infructuous. Pursuant to this subsequent orders, subsequent adjudication, these are infructuous.
What to do?
It only pray for a chance more.
What to do? What chance?
Because what has happened because of this mistake.
Please,
No, because
please consider. These orders have, there is a demand. Assessment has been made on the basis of the refund. Suppose if you reopen that particular refund procedure. Let us go to the highest of extent that the authorities thereafter found that you are entitled to a refund. Will that order be not in conflict with these orders?
these orders will not arise because of my mistake. Because of my mistake.
Will it?
It will. It will. But
If these orders are the dependent orders, these are the dependent orders where your claim that there was a human error has not been taken into account. Then the parent order got challenged. Dependent order, what you will say?
dependent order will automatically fall through.
Automatically.
It fall through because of the fact. No, because of the fact.
Something more is to be done.
I appreciate, but your lordship would appreciate that if lordship will call it next week and let me have opportunity of
Now your conscious mind to it, what to be done.
These assessment.
What to be done in this repetition. I think I can't give you a clue more than that.
Before your lordship rises, I have a humble prayer. It's number 27. I thought we had some difficulty after lunch. I've been
Juniors? You have your juniors there?
They will also be going with me. That's the problem.
Seven just take it.
We're praying for 12, subject to your lordship's time. And 25. And 25. permission
Well,
with the lordship's kind permission. There was a 4 power millers for which there was a 4 power millers for item number 27. I got instruction that some other senior counsel will be dealing with this matter. So I withdraw my submission below to be posted on the 12th. So we'll be conducting that case today before your lordship. I stayed back because I made a statement before your lordship about that. I'm extremely sorry for the confusion. And 25 for lordship kindly adjust. My learned friend, senior friend will be there. 25 maybe. Fine. Much
13 or 14 next week.
25.
Much obliged. I'm sorry for the inconvenience.
Item 24.
Please, Your Lordship. This case was it's challenging. The input order, the annexure 2 series, page number 24. Lordship. The section 7512, this is notice issued. And your order issued against the person. On section 7512. Whereas during that period, I have paid 95,000 excess tax. This section is not applicable in this case. This is very. Section 7512 says that. 7512. Section 75. Yes. 7512. Yes. Notwithstanding anything contained. Notwithstanding anything contained in section 73 or 74, where any amount of self-assessed tax
Unpaid, would be your partner.
where yes, with return on this section 39 remain unpaid. I have no unpaid lordship. I completely paid a excess 98,000 I have paid. I prepared.
Has the authority?
I have prepared a statement, lordship, for your.
He has scrutinized or not scrutinized?
Not properly scrutinized, lordship.
Not.
Do
you have the remedy of an appeal against this order?
This is a matter of lordship.
Do you have the remedy of appeal against this order?
Remedy of appeal is there, lordship, but.
So why don't you exhaust the remedy? Litigation has intervened.
I have.
2022 and 2023.
2021.
Next is 12.
2021.
Date of the order. 23.
23.
So what we will do.
Thereafter, your lordship filed 161 petition lordship filed that is still pending. Annexure
For rectification or what?
rectification of order.
That
That is still pending, lordship. That's what happened. Already demand amount of 50% already collected by the.
That we have withdrawn. Prayer number B we have allowed, we have considered. We have withdrawn because.
So what is the weight of the rectification happening?
Rectification application, your lordship,
That is still pending, lordship.
I'll take that. Page 12, the prayer. The prayer number B, second prayer, we have already considered to. We have withdrawn that attachment notice because he has partly paid the money. Part payment and undertaken to pay the balance amount. For that reason, the authority has considered that and withdrawn that attachment.
Already I have
So
paid.
that is his prayer. And the first prayer is 2022 and 23 orders have been challenged in this petition.
Answer to.
Yes.
And your ground is that they have issued the proceeding without showing the so cause notice.
Yes.
So, and what is the non-obstructive clause?
Well, that is not required. Who's the honor to
Don't sprinkle more fuel.
Yes. Presently, the recent Calcutta High Court judgment, all the construction, all the construction. Versus
What is our high court? Don't go by a Calcutta High Court, which is 400 kilometers away from. What is that the zero point distance?
There is some points, lordship, for me.
Yes, that Savitri industry, 107 Savitri industry. But that is within the period, condonable period of period. That is was within the condonable. Your lordship, those all the documents I have, but that is the your lordship, I'm well, your lordship, no, on the because Panigam. Your Lordship.
Annexure 3, Lordship.
Annexure
That
3
is
is not
page
rectification.
No, page 33.
Your Lordship. That is an application.
Application for rectification of that application is still there. If you come to page 33.
Your Lordship, even that rectification is not maintained.
Oh,
Your Lordship may kindly turn to 161.
Why will we decide? Why will we decide? Pick a call. Pick a call. You decide.
Once your Lordship will direct for disposal of that, then
Disposal has to be done. Can you keep any application pending without deciding it?
No, Your Lordship.
This way or that way, you have to decide. Let him have a clarity of their stand so that they can take further steps. You can't keep the application pending for all time.
Your Lordship may direct pending. Your Lordship. That instruction.
160 and 161.
Your Lordship, he has not cited any provision. No, 161. Rectification language is there, but no.
There are two applications he has made against two orders. One is of 16/9/2022 and one is of 29/4/2022.
Your Lordship.
Both the applications have to be listed.
Item 26.
26 is covered matter in absence. You have a different view, somebody has a different view on the constitution of the government. Your view is different, somebody has given a different picture.
Your Lordship, I am only on my instruction, Your Lordship, and I know what is going on, Your Lordship. So always I am trying to be fair because I have to.
27.
Yes, as per Lordship direction, the other day will have
This litigant has a checkered carrier.
So also with the department belongs. The little I have examined.
He is instrumental in 42nd amendment of the constitution also.
Gyanandakandi.
The second amendment, the turnkey.
Thank you, contract.
Correct, correct.
Good contract.
That's why I'm saying that is 42nd.
42nd amendment. Correct. Now those are history belongs. Yes, sir. What has happened? I have already given a copy on the last occasion, Virat, to my friend.
Yes, yes.
Yes. So what has happened? Your Lordship will find. Because initially scrutiny took place, Virat, under section 61, and the outcome of scrutiny, Virat, is allegation of mismatch between 3B and 2A, Virat, and that was Virat quantified. The amount was paid, but annexure 1 is scrutiny. Annexure 2 is the outcome, reply I have filed, and whatever they demanded out of this mismatch, otherwise this is also could have been set at rest by complying to the circular of CBC, or this could have resolved, but the petitioner paid it 21 lakh somewhat mismatch amount, and that was that, Your Lordship, because under 61(2) provides the department has to pass a routine order accepting this. They accepted this, and the provision 61(2) says, once it is paid, and accepted and paid, there is no further action shall be taken in that regard. That's the option. Then, what happened? On this very scrutiny outcome, 731 proceeding for assessment was initiated for this very period, alleging payment of interest. Interest, Your Lordship, again,
That also I paid, even if otherwise I could have challenged the loss. Because I paid, and that I paid excess amount, 7 lakhs amount they demanded. They're matter of record. My friend will fairly accede also.
Yes.
7, I paid 12 lakhs loss. More than total
Should
demand.
not be challenged on, that should not be here under challenge, because
Ah.
you have admitted, you have paid,
See,
but your prayer is that was to that order.
That order.
That should not be.
No. Question is, anything due.
He just trying to protect the income and the vulnerability of his client.
Correct.
When though the demand was made 7 lakhs, as a benevolent citizen of the country, he has paid 12 lakhs.
By mistake, I have paid. Yes.
Government should sustain.
And demand is under the head of interest. He has paid the head of tax. So that cannot be set off.
In any case, that was paid by mistake.
Let
is what I have pointed out, and they have also seen that. Then, Viras, again for the very same period, Viras, audit was conducted under 65, Viras, ending with the audit report, and again further reinitiation proceeding for the very same period under 73 Viras.
Under 74.
73, same 73 Viras. Both under 73 Viras.
Not fraud.
Not fraud, exactly. Viras. Yeah. So again, reinitiation, and also Viras, my grievance is Viras. That's I responded, I filed 2 consecutive replies, Viras. And the context of the reply, which your lordship will consider very precisely, Viras, I have taken note of it, Viras, subject to my friend's response, Viras. Viras, out of Viras, the 4 issues, Viras, your lordship will find, Viras, one is, I say there is no sale at all. So far as Viras, the East Coast, Viras, that there is no sale at all, so far as one of the parties concerned against whom the alleged belongs. And secondly, so Vedanta is concerned, Viras, they say you paid 18%, I have paid 12%, remaining tax also I have paid. There's 8%, balance 6%, I don't have dispute also, that also Viras. Now, so far as the third dispute is concerned, Viras, so that is also Viras. My only point is, but had those been considered, it is right earnest, all the what I have, my stand is Viras. And what they say, they got 73, you're actually very precisely, I am submitting Viras, 73, 170 is completed, because it is debatable yet to find out whether, as per in view of Viras, that Duncan Industries case, Viras, that cannot be 2 assessments for the same period. As you rightly said, there is fraud collusion, then 74 is there. But once Viras, completion of assessment comes to an end, invoking a particular provision, the officer becomes functus officio. If there is any other turnover is to be adjudicated, required to be adjudicated, Viras, being under assessment or escape, Viras, then for that, so much revision power is available under section 108 to the commissioner, Viras. He can initiate so much revision in case of under assessment, not correctly, Viras, dischargedly, Viras, if they are already found to be erroneous, Viras. So, the succeeding officer, Viras, in the succeeding proceeding, Viras, and the very same provision, without invoking 108 Viras, the so much revision power, which is otherwise available. I have with a judgment of your lordship, the bench of coordinate bench, saying that when there is a particular provision power available, you can't abdicate one power and perhaps
substitute with the other.
Substitute with the other, Viras. Supposing 2 are available, but one power is substantive power, which is to be invoked in case you find that it is under assessed.
Where it says
that so much revision power. Yes.
Those powers are coextensive, or those powers are separate. Which all you say that your
Lordship, kindly see the so much revision power under 108 of the GST Act.
Your first law,
Minus.
the proceeding under
60.
under section 60.
61.
60?
61 and 65. Audit is under 65.
There was a scrutiny of the return.
Correct, Minus.
And then there will be scrutiny. You say that if everything was done, the quantification was made.
Correct.
You complied.
Correct.
You deposited.
Minus.
Now,
Then also again notice Minus issued for recovering interest, Minus.
that is a different issue.
Minus.
You have also complied.
Minus.
According to you, that anything which arise or is sprung from the adjudication under section 61, you have complied.
Correct.
So according to you, that particular issue was set at rest. After the
Your Lordship, add with one word. I complied, culminating in 73 proceeding minors.
You come. Now thereafter, is 73 proceeding was initiated.
For interest in relation to non-payment of tax.
And the statutory penalty under section 50.
No. Interest, only interest, where that was paid.
So you say that 73 was also involved for interest component.
Correct, Mr.
Which you also complied.
Exactly, Mr.
Now, what the third one is that they are reopening.
Correct.
Under section
Same provision, 73.
This time on the basis of an audit.
Audit, yes.
So now tell me that if this scrutiny and audit are two separate concepts.
Correct.
Then one originating from a scrutiny.
Correct.
And another from a audit.
Correct.
Whether they are mutually destructive or they are coextensive. Or one overlaps the other.
And your Lordship have to consider, interplay of that with 108.
That is a different separate issue.
Yes.
If it constitutes an independent cause of action.
Correct.
Unconnected or unrelated with the earlier cause of action. Then is there any default or a fault on the part of the authority proceeding? So Vishwara is very happy with this query.
I'm happy because both the provisions are very clear.
He does not understand that the observation of the bill sometimes is camouflage.
Is there any restriction also? Under.
My lord,
This is a delicate question because many identical questions are answered by several courts bureaus, including Honorable Apex Court in simplex case bureaus. That at least one thing that cannot be, otherwise what will happen?
Had it been on the basis of a scrutiny, if you wanted to reopen it or wanted to reconsider, then what you say is section 108 can be invoked. There is no difficulty. If the scrutiny, any proceeding arising from a scrutiny of the return and a proceeding arising after the audit has been undertaken, if they are all independent and separate and does not overlap the others, then in that event, these are to be considered the independent proceedings. And therefore, why 108 is to be invoked?
Yeah. Question arises, bureaus.
60.
Okay. One arising from one from a scrutiny. The scope of audit scrutiny is 2 different.
61(3) and 65(7).
And whether there can be multiple adjudication under 71. That is what your Lordship.
What I say.
Correct.
If there are two independent sources.
Correct.
Or the controls, then there is no question of multiple assessment.
But same turnover bills.
Absolutely.
Same period, same turnover.
Has to be. One from a scrutiny of the return and one from an audit of the entirety. Audit and scrutiny are two different concepts. The scrutiny is of a return. That what you have submitted a return on the scrutiny, if some discrepancy or something is found, then they can develop. Audit means then they have to go into the books of accounts, they have to go into the ledger, they have to go into the other accounts which you maintain. Nowadays you are using Tally, you are using those softwares, you are not concerned. And those entries are supported by a corroborated documents. If you have raised an invoice, whether this invoice, the amount tallies with the invoice or the invoice is there or something, everything has to be tallied in case of an audit. And then the auditor gives a report. that this is the perfect account after the audit is. So it is an independent thing. If they found something else, which is not possible to be deciphered at the time of scrutiny of the returns, and can they not? I'm just asking this. Can they not?
Question Vilas is scope of scrutiny.
Maybe one financial year or one transaction.
Correct.
In relation to the same. But the source of understanding is different.
But here, one thing. Scope of scrutiny and audit. But there is a thread where may not be substantive difference.
Silver line.
Silver line, correct.
Distinction.
This is one. Number two, Vilas. That's by the time this adjudication took place on the 73. Plus, it is not that audit was not happened by then. Audit was also there. So he could have considered Vilas. Not ABR. This is not a case of.
And 73 was restricted on the basis of his scrutiny proceedings, culminating into a demand.
Correct.
And which attracts an interest, and the interest component was not paid. For that, the 73 was initiated. Only for the interest component, as you said.
It's a continuation of 61 because 60.
Absolutely, no doubt. I'm saying, had it been that they wanted to reopen by way of a scrutiny of the return, then your contention is absolutely logical and sound that they cannot reopen for the same transaction. They cannot do it, scrutiny again. If they are agreed or if they want, then 108 is the, I would say, complementary provision, which they should. But if it is a different source and a different methodology or a different way of ascertaining which may coexist, the question is whether they can coexist, whether the scrutiny of the return and audit can simultaneously coexist. If they can coexist, then you can't say the 181 is doing. If they can't do it. If they cannot coexist, their existence has to be seen. Then that even difficult.
Yes, we'll examine certainly.
Because it's an ICT.
No, yes.
Page 144 for an
It has to be considered.
Correct. There's one more thing. Apart from this, I believe your article will permit.
My mind is still open.
No, I
don't worry.
I have read this. For this periods, I also want little more periods that I will do.
Because this is something we should go on.
Nice.
Because it will impact the very, very large action which they take.
Correct. But one more thing was after this writ petition filed just within 3-4 days back, they have recovered about 1 crore.
Your Lordship admitted.
No, from the cash ledger they have taken. I don't understand whether one can do so.
Because it is appealable.
No, it is pending here. So, Hari,
4 months, 5 months.
and there is
the
79 provision also, as far as I examined, that doesn't permit recovering money from cash ledger.
Cash ledger.
Yes, they have taken money from a cash ledger. No intimation, nothing.
If it is forbidden under the law, then definitely we can entertain the writ, despite the alternative remedy available.
That is what.
If it is a manifest injustice apparent from the face of the record, then definitely we can interfere. No,
Your Lordship, that is
And ultimately, I will be
that
praying,
is
my
not
lords.
the challenge.
they will amend and challenge.
Your Lordship,
What is the
Your Lordship, that can be recovered
Can
from cash
definitely
ledger.
take notice of the subsequent event.
Your Lordship, the provision is very clear. The demand can be recovered from cash ledger and credit ledger both.
If there is a modalities provided, how and when,
Your Lordship,
then in that.
Your Lordship, because 3 months, the assessment order says the demand note assessment order as well as the demand notice issued, Your Lordship, and after 3 months, Your Lordship, the recovery is to be made, Your Lordship, as per section 79, Your Lordship. So there is a clear-cut provision, Your Lordship.
And this was
So there
done
is no-
only after last day, your lordship directed to give copy. Only thereafter this was done.
No, that should not be the apprehension that once it is here, the reply Only after the due date, your lordship only recovery has been made. So that is not the issue. Lordship,
That may be an issue.
Your lordship, because here
May be an issue.
here all are the factual issues in the assessment order, adjudication order, your lordship.
I'm on a pure question.
Your lordship.
He's raising an issue that for the same set transaction, once an scrutiny proceeding was
Your lordship.
cultivated into an order, compliance, and ultimately the entire compliance, maybe by what you have 73 proceeding or whatever
Your lordship.
has been done, can it be reopened in the guise of an audit?
Your lordship, the reopening language may not be there. Your lordship, only two provisions,
That is what
61(3), section 61(3),
do it, then
and 65(7).
Is a corresponding provision.
For a moment, 61(3) and 65(7), both the provision your lordship may kindly go through.
You are taking a greater risk. Yes, you take us, and you don't know where you
Your
have
lordship,
not
only on the issue of multiple assessment.
You have
Only
not
on the
understood me, which way my mind will go.
let it
Was
let it be there.
no. What is the problem? 61.
61(3),
Yes.
that is the scrutiny, the assessment pursuant to the scrutiny, and 65(7) is the assessment pursuant to the audit. Both 73, 74 are there in both the provisions.
It makes no satisfactory explanation.
Your lordship, we are on second 70.
Of being informed as a problem. Or sir, for the people that may do fine.
Your lordship.
Or where the registered person after accepting the discrepancy
Your lordship.
fails to take the corrective measure in return for the amount. If this the discrepancy is accepted, the proper officer will initiate appropriate action, including those under section 65, 66, or 67, or proceed to determine the tax and other dues under section 73 or 74 or under section 7.
Your lordship.
So this is what is the power.
65.
This is what is one has
The
to
first.
read. One has to read. What is the purpose of the scrutiny? The scrutiny is that in particular premised by them in the reason in the return is not accurate, and there is some discrepancy which is noticed by an officer while processing that. Then subsection 2 says that he has to ask for an explanation. That's a right to provide explanation. Third is a repository power, which says that in the event the officer finds that the reply or explanation is not satisfactory, then he can proceed either under section 65, 67, or 73, or 74, or 24A. Here is a case where you have
Found to acceptable.
Accepted.
Accepted.
you have been satisfied, and they have also accepted, and the once it becomes an acceptable situation.
Only 73 in place.
73 was involved for the correct of interest.
Correct.
So
Now-
discrepancy goes.
Your lordship.
It is no longer there is any discrepancy.
Your lordship.
Now you are 62.
65. 65(7). Your lordship has held that from the same source, multiple cannot be done, may not be done. Different source, your lordship.
Now I am.
But allegation is one.
No. In the audit, different paras are there.
Same returns.
Your lordship.
Same returns, same turnover, same figure.
Audit obviously on the same.
When you have supernumerary returns, you have the same figures and you have, I may use the word subjective ITC, the same thing I have seen. Audit is also made on that perspective. I've seen.
Audit only one issue there is ITC, but here multiple paras are there.
At that time you could have taken a audit.
Let us see, that is what I was going to ask. 61(3) when the referred.
Or
had an opportunity to initiate a proceeding under section 65. Having not chosen to go under 65. And having chosen to go under section 73 for the purpose of an interest. Now, how 65 is to be invoked?
Your Lordship, 65 on two different aspects. The commissioner, Your Lordship, 65-1.
61-3.
Your Lordship, 61-3, 61-3 is one.
Corrective measures, the proper officer
Your Lordship,
may initiate an appropriate action,
Your Lordship.
including those under section 65. That means the power to initiate or take action under section 65
Is there?
on a proper officer.
Mal.
Right? He chose not to take any steps under section 65.
Mal.
He chose that I should take an action under section 73.
73. Correct.
That means he did not have any kind of a confusion or a discrepancy in his mind that it needs a 65 to be invoked.
Your Lordship.
If he ruled out the applicability of section 65,
Your Lordship.
subsequently, whether the commissioner can.
Your Lordship, that is the audit cycle. Your Lordship, I'll convince Your
Who
Lordship.
he initiated 65? The proper officer or the commissioner?
No, proper officer have initiated. Your Lordship, there is a, but I convince there is
joint
a
commission.
cycle. There is a audit cycle, Your Lordship, because every dealer there cannot be any audit. For every period, there cannot be audit. So there is an audit cycle of the dealers.
At such frequency,
Yeah.
of such manner as may be prescribed.
Your Lordship.
So it should be done in a interval.
Your Lordship. Thank you. Last taxpayer unit.
If the power was given to a proper officer to initiate under section 65, having not found, now you tell me that what is the outcome?
Outcome of the first proceeding.
It did not like the element of the audit to be done.
I propose to initiate your case.
65 is there, the power was there with the initiate. Once he chose to exercise the other power, that means impolitely, he was satisfied that the other course is not open.
Express ruled out rather, not impliedly.
That part may not how this case has been scrutinized for audit. I
tell you, had the subsection 3 does not contain the section
65.
the position was different. Once it's contained, then.
But here you not say for the
Here means what?
60 here.
If there are multiple powers which is there and only one has been invoked, that shows that the other power, there was no material to invoke that power.
Memo number 1 that has been adjusted. That amount of 144. That is one of the.
That was there prior to that.
That is one of the. That is one of the memos.
Twice next with the same problem. 3B1.
What is that legal action? Judax or what?
Cannot be.
Person cannot charge of his own.
What is this Duralex?
Correct.
Impossible.
Many person cannot judge it from
Same cause, one might not be
Person
vexed
cannot be
twice.
a judge of his own cause is a different one. I'm saying a person cannot be vexed twice. For the same
For the
offense.
same cause.
For the same cause.
For the same transaction, one person cannot be vexed twice.
For the same transaction, you not same transaction.
Page 141.
144.
Very.
100. There are 4.
Your returns and books of account submitted.
Obviously,
Nemo debit bis vexari pro idiom causa. No one should be harassed twice for the same cause.
What is that, Phil?
Nemo debit bis vexari pro idiom causa.
here it may not be applied here. Say found here may not be because whatever the 61, your lordship, that has been adjusted.
You see, initially my impression was that both have connotations.
Your lordship.
The scrutiny and the audit are the two different concepts. But attention of subsection 3 was not drawn. I am thankful that you drew our attention to subsection 3.
With great respect,
Now
author
when it says that authority can go for an audit, the proper officer, and having chosen not to go for an audit, whether subsequently the commissioner, what was the material before the commissioner for an audit?
your lordship, that I have to call for the
There
internet.
was no material because the return were there.
Same thing.
petition
No
was there,
audit.
the discrepancies, everything was there.
But what I understood, what I know, your lordship, my lord justice can also say, your lordship, because
Why
audit.
should I say?
Your lordship, because Nagi is from. Your lordship, why I'm saying so? Because in tax audit cycle, there is an audit cycle. Because in tax or last tax per unit, there are so many criteria.
That was there.
No, baby, actually, even in
No,
this
I understand what you say.
yeah, let's see. So on different cycle that has been scrutinized. That this dealer will pay audit. So
According to
accordingly,
you, one who pays a large amount of tax
your lordship,
will always be under scrutiny.
your
The
lordship,
person who does not pay tax or even pay a smaller tax will not be under the scrutiny.
your lordship. But what my
So
there
what-
cannot be there is no double taxation here. There cannot be any repetition here. Whatever amount has been paid on the 61 and 73, that has been deducted. That has been allowed credit.
Sir,
Your lordship.
simple way of putting a thing. Who disputes? The question is whether you can reopen by taking a circuitous route of the audit. Once you have finalized and closed the matter on the scrutiny.
Your lordship, I'll convince.
9 query to score 850 is 200.
61.
This court. This court. Right.
That is under different context. That is under different context.
Yes. Yeah. 9 query to score.
Don't get elated by our observation.
No. I'll convince you.
This is only to exhaust the energy level of Mr.
My gosh.
The principal
He's very young, energetic.
The principal laid down was a person cannot be twice audited.
It's different. Here this is different. Here it is disjunctive. What with great respect, your lordship. 60. Your lordship 61. Once you have not chosen to 65, that does not mean that you cannot go independently 65.
61.3 states at it.
Yes. 61.3, multiple. Your lordship, I raise my, your lordship,
Yes, section 8, that the authority is empowered to take any action, say A, B, C, or D. He can take recourse to any of them. A, B, C, D. He chose, after the entire consideration, to invoke D. What logically deducible therefrom that he did not find that any action is really required to be taken under A, B, and C. If he was satisfied that no action is warranted under A and B, C, only under D, then how can you say a different? That shows that he has not found any element for the purpose of ABC.
Great respect, my lord. Sir, what
You
I
are
understood-
talking about disjunctive.
What I
All are disjunctive.
Your lordship, what I understood with great 65, there are two links. One is consequential and another independent, your lordship.
No, I understand. I don't think that I do not. I understand.
Your lordship. So consequential, suppose you one consequential, one left, authority left. That does not mean that it cannot go independent. So it can suppose I'm putting a question to myself. I'm putting a question.
Innumerable time.
Your lordship.
Innumerable time.
Innumerable times. No, innumerable times. Your lordship, one question I put myself. Suppose there is no 60 over.
Audit?
Exactly.
Independent audit.
Exactly. So 65, that can be 65.
That is what I say. That is what I am asking. If there is a provision which is given, then does it not mean that it becomes a consequential one? If you have, there are two multiple sources of the invocation of a particular provision. If the consequential one is ruled out, does it mean that the independent cannot be ruled out? I'm just asking this question. That's a double jeopardy. They are vexed twice. Then why not it overlaps to some extent, have got an overlapping provisions?
I have to prepare my.
This doctrine of overlapping.
Yeah, let's see.
Or he correctly says the interplay. Between 61 and 70.
This is neither reopening. Your Lordship, the language of reopening may not be suit here. Your Lordship, but this is an assessment pursuant to audit, Your Lordship.
No, it is not using what my lord says.
I'm sorry.
You have chosen.
Your Lordship, I can understand. Yeah, I can understand.
Chosen one course of action.
I have to.
That culminated in a result, and that was complied with. Thereafter, can you take another recourse?
I think I make my learning seniors work very easier for Your Lordship.
No. Have you not heard what I said?
Your Lordship.
Then don't get encouraged with these discussion.
No.
It's a shifting balance. We don't know. The pan will tilt.
Your Lordship, I've seen in many cases. I've seen Your
It
Lordship.
will tilt in which way?
This great institution in the past periods have dealt with hundreds of batch of cases, my lord knows, IPR 89 cases. All are enjoying stay bills, not collecting any tax, and they were passing on the benefit to the buyers ultimately. And all of a sudden, when it was dismissed by our High Court and confirmed Supreme Court, that the outcome is such the entire liability outweighed their capital assets. It so happened. So we understand, because stay the bitter pill always, you understand, many a times, many a times.
Yes. Let us argue on this point when.
Your Lordship. Your Lordship.
Lordship is suitable if it
What is convenient to do and date code?
No, sir. 20th. Let me see the 20th, my friends also says.
Last week.
Oh, tell me the date, both of you.
Decide.
September.
My friends are just saying first September. Provided no further money, already taken 45 lakhs.
You said 1 crore.
No, I checked up, I'm sorry, 45 lakhs. In two spells, they have taken 45 lakhs. There are another entry, but that was not. Two entries.
Yes. Everything is taken away. 45 lakhs.
No.
It's still a huge.
Yeah.
2 crore 60.
2 crore 60.
You have taken how much? 20%?
About.
7.
Apart from money which I have already paid in excess also.
Nearly 20% you have already.
Okay. As per my Lord and Senior statement.
When you take it.
Because statement varies time to time, so that because just with great respect. With great respect.
Yes.
I'm sorry.
Caste.
And the interesting point is basically you see, that
today, 3 items is there. Lordship, second item relates to 74 P. Lordship. 74 P item. And first item relates to multiple assessment here in a so all are covered.
And the third,
Same lordship.
what?
Multiple assessment here.
So two are multiple,
One
is divided, 74.
73 4B limitation.
73 position.
Limited.
Just stated the numbers.
Lordship, corrected and concentrated. Corrected. Item number 1 to 3.
Lordship, sub-item 1 and 2, I need a copy. I am also filing this case.
But here is a copy here and now.
Lordship, immediate place.
Only sub-item 2, if the lordship will see whether the petitioner can take that grant of limitation of the, I mean, doubt now. Because your lordship,
The doubt would be cleared on the next day when the matter would be lost.
because the petitioner has himself sought for the time in the adjudication procedure. Now he's coming with the ground that limitation is bargain. I'll file it with the count.
And your authority has not set up his own limitation.
Well, during that time, that extension of the limitation by the.
Item 29.
And easily. Please spell it. And please. Kitchens of GST.
10%, yes.
Item 30.
So,
30.
Service tax matter that is covered by a law, so that's what I have.
All the three matters.
2 matters. 31.
31 was covered by not in absence of GST.
Item 32. Item 32, sir.
Yes. I am for the opposite party.
Yes. Avinash, I am.
Remember on the last occasion, I was saying that taking from clear they are from last about 5-6 occasions he has taken time. This readability is not maintainable. I was submitting to your lordship. It arises out of the petition. Your order passed in that petition has already been acted upon. He participated in that proceeding. Now he is filing an appeal.
Audit.
That was, he was given a chance to file a reply.
Final order passed by the.
No, disposing of the petition, the direction was passed on the.
Yes, ma'am. Yes.
Issue of response.
Yes, ma'am. Yes, ma'am.
And then, after this, he will appear before the committee. And before.
They appear.
Relevant document, 4 weeks time to file.
They appear.
Reply or receipt, then this will finally. That is done.
Yes, that has been done. This order has been passed.
Reply.
Yes, ma'am.
He's given a reply.
Yes, madam.
So he has rather complied with the order.
Yes. Thereafter, he is filing a appeal.
So we are, then we discuss the matter for the court.
That's what my prayer was on the last one.
Because. Yes. Let's. Record their name, discuss what they want.
Filings of note I can it's just one fast.
No, we have discussed it possible. Where you were?
Kindly just consider.
You don't have the power. You don't have power. Oh, where is Mr. Avinash Nayak or
Mr.
Mr.
Mistry is
Mishra?
coming, your lordship. Just one person. Kindly consider, your lordship.
So,
Just is coming, your lordship. On behalf of Mr. Mistry, your lordship.
no, we have already passed the order. Laptop is also, there was an adjournment. No, everything has been done. Where is Mr. Mishra? Mr. Nayak?
In somewhere, the court says the following person. Kindly consider.
Call him.
Yes, just one person.
Call him.
Yes, sir.
Immediately.
Yes, sir.
We'll take up this matter at 3:30.
Yes, sir. No. Let's go.
Item 33.
And item 33, two matters. The first readable
Yes.
the two readables connected matter. I have filed a short note on case law matter. The first readable 976 challenging order under Annexure 4. And here, during pendency of the read petition, the contesting private opinion of 5 and 6, they died, my lord. I have filed death certificate as under Annexure 1(3). We are their legal heir. We have not been substituted.
What are they talking about, sir? Who are you?
And
Who are you in the requisition?
we
I
are
am
the,
looking at the annexure 4,
yes,
order dated 8/4/25. Yes. Who are you?
we are the legal heirs of original OP number 4 and 5.
In the requisition.
In the read petition.
OP number 4 and 5 were alive or dead at the time?
They were dead during pendency of the read petition.
So you were the writ petitioner. Your father was the writ petitioner there.
Yes, no. They were the OP number 4 and 5
In the writ petition.
again. The read petition was disposed of without any substitution. We filed a miscase and leave petition that we are not substituted, so we may be hard in the read petition.
So there was nothing. The court has said that giving liberty, you will be impleaded in a proceeding which is pending before the sub-collector. So whether you were impleaded there.
No, my.
What are you talking about?
Well, there also we are opposite parties. They are to file appropriate application.
Why? Who says that it is them to file?
But the law is where
what is the provision for substitution?
Well, that is order 22 rule 4.
Does it say that it is only the plaintiff who will apply for the substitution? Please look at order 22 rule 4. Does it say that it's only the plaintiff? Only the plaintiff who can apply for substitution of the heirs of the legal the deceased defendant. Then.
Where one
or more
defendant dies, and the right to sue does not survive against the surviving defendant or defendants alone, or a sole defendant or sole surviving defendant dies, and the right to survives, the court on an application made in their behalf shall cause the legal representative of the deceased defendant to be made part.
So application in this behalf by whom? As he said, on the plaintiff. As he said so.
Made party and shall proceed with the suit.
Who can make an application? He said. Tell me. That is only the plaintiff who can make an application. The provision says an application made in this behalf. So it can be filed by the plaintiff, it can be filed by the substituted heirs. Seeking their substitution.
No.
Why didn't you approach and get yourself substituted? You wanted this,
No, my only point is, the law says where death occurs, substitution to be carried out there only. I have filed condition.
even a death prior to,
No, it is death during pendency of the writ petition.
when the 4 and 5 died, prior to the writ petition or after?
During pendency of the writ petition. I have given death certificate. Opted for died. Opted for died measure. Opted for died on 23/4/2007.
When the writ petition was filed?
2006. Then opted 5 died on 28/7/2016 during pendency of the writ. Writ petition was discovered in 2022.
What would have been?
Writ
What
petition-
would have been the fallout? Suppose your application for substitution was pending in the writ.
No, we filed an IA that we may be permitted, leave may be granted, and we are the legal rights of opinion of 4 and 5.
That being the submission you wanted.
Yes. In place of
Yes. You wanted a substitution in place of OP 4 and 5.
right, yes.
The court, now, yes, they are dead. Say that I am not going to decide anything in the writ petition. In miscellaneous cases pending before the subcommittee.
After remand.
So it says that yes, you be, since you are the heirs, you be substituted there or included there in the proceeding. So you have to approach the sub-collector in the miscase. Say this is the order. Substitute us, include us. You can't proceed in our absence. How you have challenged this one? There is no right decided against you. You can't be a person aggrieved.
But the writ petition has decided against the dead person.
No,
Opinion of 4.
there is no decision.
Yes, decision.
What decision?
Annexure 3.
When you are talking about that concept that the order passed against a dead person is a nullity, then you should know that whether the order adversarially affect a dead person or does not. A order passed in favor of a dead person is a nullity. Now I'm asking a question. It appears that you are talking about a civil law. A order passed in favor of a dead person is a nullity. Till. You are seeing an order passed against a dead person is a nullity. In favor of a dead person. If plaintiff filed a suit, plaintiff died during the pendency, but nobody brought the heirs on record, proceeded, and a decree passed in favor of the plaintiff. Then there is a nullity. Sir, nothing. Only thing is that if it is passed against a person, means a adverse order affecting some rights of the dead person. If that being the position, you are correct. But if the order does not affect the right, it simply says that since the matter is pending in the sub-collector's court, you go there and contest that proceeding as a year. Right?
The writ petition was filed challenging annexure 2 and 3. Those orders are passed against the writ petition. They challenge. The orders were quashed and remanded. The 23A proceedings. The writ petition.
I do not find from this order of 8/4/2025.
No, the first order. The second retable. It is second. But the retable 976, we filed an IA for a leave.
Sir, this is 15371 of 2006, sir.
Aye.
So,
sir, two retables. One is challenging order 8/4/25.
sir, I am talking about the final order which is passed.
Yes.
I'm talking about the final order, which is disposing of the repetition.
That is 8/9/22.
No, this is 8/4/2025.
Sir, say order correct phone out and
8/9/22, sir. 8/9/22.
8/9/22. That order is passed.
16.
Page 16.
Yeah.
But that order is passed.
Then the order.
That is 2007 and 2016. Disposable 2016. 2007 and 2016.
Represented by a counsel who appeared for 405.
Sir, 405 days.
He appeared. Wakalatnama is fine.
In the writ petition, their name reflects. Their name.
No, on that day they also appeared. The order sheet records that they appeared for 405. 8/9/22.
Yes.
On 8/9/22.
Yes, the order sheet reflects the name of opinion forum. But they could not. They should have mentioned that opinion forum type of elder.
After all, the matter is relegated back to the authority without deciding anything. It's better you go there, find out whatever the ground you want to take. These are the two appeals you have done.
Yes, ma'am.
Which one is against which?
But the first 976 is challenging order 8/25.
Yes.
And second writ appeal 970 challenging order 8/9/22.
So the appeal barred by limitation.
I have filed limitation.
Application.
Yes, ma'am.
Why you did not say that there is your repetition?
Yes, ma'am.
What is? Which one?
That will be IN number 2732.
You have been served with the application. Renovation application.
Yes, ma'am.
Yes, yes, sir. No, 732.
Thank you. Thank
Yes. Have you been served with the call?
Yes.
Good. How much day is giving? Must be 700, 800.
Yes, ma'am. 2022 order challenging 2020.
Six at Paris Paris.
965 days.
Well,
965.
Say nearly 1 year. Usually
965 days, ma'am.
Oh, sorry, 3 years.
3 years.
3 years. Yeah. For contribution of delay of
Item number 32, sir.
Yes, my lord. Everything you have complied the order, Shukor's notice was issued upon you filed a reply.
Yes.
And then it's culminated into an order, then what remains?
My lord, may I be permitted to place just few things, your lordship?
I am simply asking this question.
My lord.
If you were dissatisfied with the order,
My lord.
you could have immediately asked for a stay of that particular proceedings that not to be initiated. Instead of participating and filing a reply. If you have partly complied the order, then in that event, can you challenge the order?
My lord. My lord, though I have filed the show cause, but your lordship, my prayer in the writ, also for the writ of him, that remains alive, my lord.
There was a direction that everything has to be initiated afresh.
My lord.
Show cause notice, reply, opportunity, final order.
That is before state level scrutiny committee. May I submit, my lord, only small thing, my lord. The petitioner has come up before the Honorable Reed Court, making a prayer that there should be a fresh reinvestigation by the DVC, District Vigilance Cell, that is as per the on the judgment of Kumari Madhuri Patel versus State of Maharashtra. What has happened, my lord? In 2020, a report was called for from Tahsildar of the local area, Mahakalpada, Kendrapada, and a report was called for from SP Kendrapada. Now, Tahsildar submitted a report in my paper. The SP through SDPO made a query and submitted a report against me. Now, since there are two contradictory reports, the SLS State Level Scrutiny Committee in short SLSC, they issued me a notice to file a show cause as to why two contradictory reports have come. I submitted a detailed show cause.
For you to see that why contradictory.
That is SLSC should be a notice. That notice I have annexed.
Who are you?
I am the agreed. My caste certificate is under challenge.
Sir, you are an individual.
My lord.
There is a report submitted by the police administration and there is a report submitted by Tehsil.
My lord.
Two different. There is a contradiction. One says the caste certificate is genuine. One says caste certificate is ingenuine.
My lord.
Contradiction only to that extent.
My lord.
Why you will be given a show cause? It is the authority who have to take a call that whose report is to be accepted more reliable and whose report cannot be relied upon.
I have been issued a notice to file a show cause to the report submitted, not to the contract.
The report. What the report is not within your hand.
No, my lord.
They must have taken up one report,
my lord,
which goes against you, and then issued a show cause that your certificate is not genuine and why this step should not be taken against you.
My lord. Then I submitted a show cause.
Don't distort the facts.
No, my lord. I am submitting, my lord. Then I submitted my show cause. On my show cause, SLSC has been pleased to reject both the reports and to call for a fresh report.
True.
Thereafter, your lordship, my lord, from collector Kendrapada and SP Kendrapada.
Again, 2%.
That is to be done jointly, my lord. There is a joint inquiry is to be done. That is Annexure 3, page 44. SLSC on objection found it that two contradictory reports are there. So a fresh investigation is to be done jointly.
Yes. So fresh investigation by whom? The collector and SP.
My lord.
Then what happened?
By that time, your lordship, the Tahsildar who has submitted the earlier report, he has been already transferred. So the collector again entrusted it to Tahsildar, but the Tahsildar who submitted the earlier report, he was not there. And the SP, though that has been directed by SLSC to look into the matter personally, that is the word, your lordship. The SP handed over it again to the same SDPO who has submitted the earlier report. That is the reason, your lordship.
Then what?
Then, my lord, I immediately challenged it before the Honorable Court. Honorable Court.
What challenge?
I challenge that the person who has whose report earlier has been rejected on my objection
the same person may not be entrusted with the investigation charge because he being a.
So by this time, the report did not come.
No,
It
madam.
was only the entrustment.
Only the entrustment. Then, Your Lordship, Honorable Court has been pleased to grant me a stay on 2/12/2020.
Then
I communicated it to the concerned SDPO that there has been a stay, and my family member. And my family members.
when it was?
That is page.
No. When the stay order was granted?
2/12/2020.
12/2000.
That is page 93.
Then
My Lord. Then I made a prayer that at 2/12/2020 on that day, Your Lordship may kindly consider the COVID was at peaks. So I made a prayer for the SDPO that I have got an order from the Honorable High Court. I'll produce the copy because he has posted it to 4/12/2020. I filed an affidavit along with the cause list of the Honorable Court that I'll produce the certified copy, the copy available on the net immediately once I get it. But I may be given few days time. And the family members are suffering from COVID. I have even produced the documents that I was suffering from COVID, and there are government documents to that effect. But without giving me any time, without even accepting my affidavit, on 4/12/2020, the SDPO submitted the report against me again. Now, thereafter, Your Lordship.
And what about the Tahsildar?
There is a joint inquiry done. Tahsildar has accepted the report what has been signed by SDPO. Then in the writ petition, my lord, which was pending by that time, all these things were agitated. The Honorable Court has been pleased to dispose of the writ petition with a direction to raise all the points, because by that time the report was before the SLSC, but SLSC has not yet accepted. So Honorable Court directed me to raise all the points regarding bias and documents I am producing. He is not considering, because he is a public servant, he will definitely try to stick to earlier report. So all these things have to be raised before SLSC, and SLSC has to take a decision whether that report is to be accepted or not. Then I raised all the points. On 18/12/2024, my lord, SLSC passed an order that the report we are accepting, and on that report itself we will proceed. That order dated 18/12/2024, I challenged before this Honorable Court. Now, this Honorable Court has been pleased to pass an order on 7/3/2025, wherein it has been stated, though my prayer is that the report is to be rejected, but the Honorable Court directed me to participate, and by that time, 2023 rule, verification of caste certificate rule has come into force. So that rule is to be complied. But regarding rejection of the report, the Honorable Court didn't allow my prayer and directed me to participate. Now, Honorable Court directed me to appear before the SLSC on 21/3/2025. And SLSC was directed to give me 4 weeks time to file my reply. On 21/3/2025, I appeared and made a prayer that Honorable Court has granted me 4 weeks time. Now, on 21/3/2025, though it is a fact that the Honorable Court has directed SLSC to grant me 4 weeks time, SLSC rejected all our caste certificates on that date itself. Then, Your Lordship, that order I challenged immediately before this Honorable Court. This Honorable Court on 9/5/2025 set aside that order and restored the order earlier passed on 7/3/2025. Therein, on 9/5/2025, when in a fresh writ Honorable Court passed this order, Honorable Court has been pleased to quote the earlier order that this is what we have directed, and 4 weeks time are mandatorily to be directed to be given. But it has not been complied. So the order passed by SLSC is absolutely per se illegal. It was set aside. But therein, the order dated 7/3/2025 has been directed to be complied, and Honorable Court has been pleased to quote the entire order. So that again I have challenged in writ appeal number 1082/2025, because my prayer still remains the same.
What do you mean the same?
My prayer is, Your Lordship,
that they have accepted the report, wanted to challenge it, says there's a show cause. When they give, you can take all such pleas there in no reply. So that was the only thing. So why the court will interfere? That order has to be complied, and that order attained finally. Because you challenged that order in the appeal and that was not accepted.
I have never challenged it in any appeal. Honorable Court in the earlier read directed me to file a show cause with all objections regarding acceptance of report.
Correct.
That I have done.
So that is you have done, that's all.
On 1812.
And subsequently you wanted a time.
No, my lord.
What? The
18
time was rejected and then you came before the court granted you 4 weeks time to file your
My
report.
lord. But in that read.
But on the day when the order is passed, he has concluded the proceeding. The court has already passed.
Yes.
And permitted.
Yes. My lord, my prayer.
That permitted you to go and file your reply. Even the court has gone to great extent and giving you that a fresh show cause notice to be given.
The fresh
give a reply.
My lord. But my prayer that the same investigating officer whose report.
That will be decided by the authorities. Because that portion is still open.
Yes. No, my lord. With respect, my lord, that is rejected.
Now, then it's a fresh cause of action you will have to challenge. That he has not taken into consideration this aspect, despite this specific observation of the court, that they have to decide whether this report can be accepted or rejected.
That has not been done by the honorable.
It's a fresh cause of action after compliance of the order.
After the order dated 7/3/2025, which I am.
You gave a reply, you must have taken that particular plea that the report should not be accepted.
Yes, my lord.
And if they have rejected it, then give me a fresh cause of action that they have not considered this point.
That is exactly what I have done, my lord.
So in the appeal,
in the
against this order.
My lord.
After that, the show cause, reply given, everything now culminated into order. That order is an independent cause of action.
My lord, I may be permitted to submit, my lord. After the order dated 18/12/2024, my lord, when I challenged it before the Reed Court, the Honorable Reed Court didn't say to raise those pleas again before the SLSC. Honorable Court simply said that that report is to be accepted. There is an observation by the court that the report which has been accepted by SLSC is correctly done. There is no observation thereafter that whether the same investigating officer can continue or not.
No, this is not a case of a same investigating officer should continue or not. The question is that the liberty, where is that order? Liberty was given to you to agitate all the points before the authority, SLST or whatever.
My lord.
You'll have to, where is that order?
That order, your lord says.
Show us.
My lord.
Yes, 35 of WA 1082.
What is the date of the order?
Page 35.
9/5/2025.
I am submitting that order. I am just closing.
Paragraph?
Paragraph 8 of page 35 in the second read application. Second read appeal, that is 1082 of 2025. A relevant portion of that order is at page 35, para A. This has been included.
Oh, no, I am talking about the earlier order.
My lord, that is page 133.
By which he was permitted to raise all the objections.
That is page 133. Read up 133, WA number 611/2025. 133. Your lordship permits.
Yeah.
No. It is available at page 163. My friend is wrong.
No. Order where I have been directed to place it before SLSC. That is 133.
There is a 9/2024 order.
My lord.
9/2024 order.
My lord, that I have. That is at page 46, my lord, page 46 of same writ appeal. No, page only 46.
Everything was kept open by virtue of 9/4/2024. You challenge this order.
I appeared before SLS and filed my so-called.
Did you challenge this order of 9/4/2024?
No, no, my lord.
You accepted it.
My lord.
Then you went to the SLST.
And raised all my objections.
Correct. Then what the SLST do?
SLSC said that the same report submitted by same SDPO will be accepted.
Accept. Then what you did
That I challenged before in the writ appeal. That I challenged the writ, press writ. That is.
Where is that?
My lord, that is the order your lordship at page 164, 63, but the relevant portion is 166. That is writ appeal number 611/2025. At page 611/2025.
See the writ petition number.
The writ petition is WPC 4774/2025.
Page
163. The operative portion is 166.
Yes.
Page 166. Paragraph 6.1. Since the report so submitted by Vigilance Cell on 4/12/2022 was the subject matter of challenge for this court and the same was only accepted by order dated 18/12/2024, it is the view of this court that the petitioner should have been given an opportunity to file his reply to the said report and thereafter the committee will be free to proceed with the matter in accordance with law.
No, that is what is the order.
Yes. Then thereafter, your lordship.
And in terms of this order, he participated.
I filed a only objection as per the compliance because subsequent date. Because subsequent date on 21/3/2025, where I should have been given 4 weeks time. On that day itself, all our caste certificates were cancelled. So I was compelled to file a fresh writ. Thereafter, your lordship kindly say the honorable court has written.
Let's set aside the order and directed the fresh proposed notice to be issued.
Yes, ma'am. 18/12/2024 has not been set aside, my lord.
Every order goes 7/3/2025 order which is placed. Paragraph, you have placed paragraph 6.1.
My lord.
I have seen paragraph 6.2 as well.
My lord.
And then the court has said that no fresh proposed notice is to be given by their appearance.
And after he participated.
If they have decided otherwise, then it's a fresh cause of action.
My lord. Your lordship may kindly dispose of the writ appeal in that line.
It is not maintainable, there's vice versa.
No, your lordship may, I'm making a prayer.
Noticing yes, in vice versa dismissal, and then if that is there, then fresh cause of action will agitate the points, that's all.
Your lordship may permit me to withdraw with a liberty to file a fresh writ.
During that order. So what is the other appeal?
That is, when that 21/3/2025 itself, my caste certificate was dismissed by the order, clear violation to this honorable court's order. There I challenged in WPC number 9959/2025. That is, so therein, my lord have been pleased to say that 7/3/2025 order is to be complied. That is writ up.
So that is the correct one.
Yes. My submission, your lordship, my prayer for a fresh investigation by another authority.
What is already open in that regard.
My lord, your lordship may permit me to withdraw with the liberty to challenge the order. My small prayer.
In which appeal there is a delay?
The order dated 12/3/2025 passed by the SLC, which was already in impugned order in 35, my lord. See the prayer part, my lord.
What prayer? What is the preamble of 108?
Possibly my friend couldn't express it properly.
Yes.
In the first state appeal, the order which has been assailed, 7/3/2025 order.
Correct.
By virtue of that, the proceeding was there. He participated and order was passed. That is 12/3/2025.
Correct.
That order he challenged in another petition. The other day I gave copies of that order.
What is 12/3 law?
One.
12/3. This is the order of 12/3.
Yes, ma'am.
He
He challenged in another writ petition, that is 9959.
This is also dismissed. So fresh cause of action is
Arose.
already there.
Yes, ma'am.
So he has challenged this.
Yes, ma'am.
He has challenged
And
this.
he has not said this thing in the writ appeal, although writ appeal was filed
Where is
afterwards.
the order permitting you to grant 4 weeks time?
That
That is in order of 7/3.
That is 7/3, my lord.
7.
So this order has to go.
My lord.
1082, this order has to go. That writ petition.
Yes, I don't dispute that. Only I was.
99959 of 2025.
Yes, ma'am.
The order has to go.
Yes, ma'am.
It will go, giving you a liberty to file a the reply.
If it will go, my lord, what will happen? Then the SLC's final order will be in force.
Oh, that order is gone.
Yes.
This order is gone, sir.
Yes, my lord. Yes, my lord. I want to say that.
Paragraph 8.
Yes.
Yes, ma'am.
So where is your difficulty?
Already it was.
Yes,
by
yes,
the
yes,
civil
sir.
judge.
Where is your difficulty?
My lord, 12/3/2025.
Order is, I am inclined, this court is inclined to quash order dated 12/3/2025.
Yes,
My lord.
It is okay.
And the appointment on appearance of appointment one shall take up the matter.
On 4 June.
Dispose of the in the light of the order dated 7/3/2025.
Absolutely. That should be.
And on that day, he made a mention in this court, before this court, that I am going to SLC.
Because that meeting
That
was
he
there
made
on
a
that.
mention here.
What has happened thereafter is still pending.
My lord, still pending. I filed a
You
SOCA.
filed the reply, so much reply on that day. Yes, that is also.
No final order has been passed.
No, my lord.
The final order has been passed, your lordship. Not final order.
Final order.
By so cause has been
My lordship.
so cause has been rejected. Again rejected.
So cause is rejected, I do not know.
My lord.
Should cause is rejected, I do not.
So cause means with a prayer. Another prayer I have made that the 18 that the report submitted by the same SDPO should be rejected. That has been declined.
It is not declined, my lordship. It is the order 9/7/2025.
Yes, yes, ma'am.
That
Because of many orders, your lordship, please.
Sorry.
Because of many orders.
You have been able to create a lot of.
It's the 7th litigation, my lordship, in this court. 7th litigation.
No, I have not filed.
Wait for 8th.
I have filed only this writ petition. Respondent number 9 has filed earlier petition. I have not filed. I do not dispute.
So party to that litigation.
The respondent.
The case has a checkered history. Yes, for the next.
Item 34.
Please. Yes, my lord. Setting the order of the Honorable Civil Judge, directing us to deposit 1 crore and then approach the bank for directing the applicant appellant to deposit 1 crore, so approach the bank for settlement of the dues. OTS defacement basically. Now, after the appeal was filed.
Any action under.
No,
Or under the recovery what?
I'm just coming to that, Manoj. This matter may kindly be called on 11 because as we speak, my instruction is they are negotiating with the bank in the head office. So they will know by 7th, Manoj, the outcome of their endeavor. Either replacement or
Demand was raised. Under the Sarfasi NPA.
I am for the bank matter. And I have already filed a caveat petition before the Honorable.
But the copy has not been served.
Caveat petition.
Cannot be any caveat petition. It is unknown to me.
Yes.
This expression. You have lost the caveat. You are entitled to a copy before the court proceeds to pass an interim order.
Caveat was probably not by the writ appeal.
That is under section 148 capital A of the CPC.
I have been instructed to appear in this case.
Let it come on.
Give him a comment.
I'll give him a
petition.
Bank has already.
Writ appeal. I'm sorry.
You have not filed any challenge.
Not in the appeal. We checked up.
Then the order is to be passed on the petition.
No, I have been instructed to appear in this case.
Say that. No, it's no formal.
And change your stand because of my expression.
We checked up.
You are getting, you are not getting.
No caveat.
Caveat in 37/2025.
WPC. Yes, filed WPC. Read.
Earlier WPC that
send a copy.
With a direction to pay 1 crore rupees.
I'm not making an issue of that. I'll serve him a copy.
This is because of the account being NPA.
Yes, my lord. The account has declared as NPA. Thereafter 32 notice has already been issued. 13(4) notice.
Objection?
No, they are not giving any objection. No.
13(4) action taken?
No, 13(4) notice has already been issued. They are suppressed all these facts.
Under section 14?
No.
Have you approached under section 14 for 13(6)? I am asking you.
After 13(4). After 13(4), we are.
Have you approached under section 14 before the magistrate for passing an order for taking a step under section 13(6)?
No,
or under rule.
As per my
secularization rules.
As per my instruction that the earlier writ petition has been filed that vacation of intimation to sell notice.
What you challenged in the writ petition?
Intimation to sell notice.
Just one thing.
6.
Have you challenged this surface action in the writ petition?
No, yes, in the surface action.
In the writ petition lie.
In the
writ petition lie, Mr. Palit.
Under 6, 8, but one second.
Section 17 is the remedy there. You can approve the.
I'm conscious of that.
Writ petition.
I'm conscious of that view taken by your lordship, Manoj.
No,
I have
taken by Supreme Court.
And also, Manoj, your lordship has reiterated. I'm aware of your lordship's view, Manoj. Here, Manoj, your lordship may kindly Manoj. I'll draw your lordship's attention kindly to the second prayer. Issue a writ of mandamus or any other appropriate writ or direction commanding the opposite party to consider the refacement proposal submitted by the.
No realize.
No, that is.
No,
I was only
from a very old judgment of Madia Chemicals, then
Madia Chemicals is there.
The whole judgments of the Supreme Court.
The line of judgments are there, Manoj. Difficulty here is this.
First judgment is Madia Chemicals.
Madia Chemicals. Madia Chemicals, Manoj, it was that created quite a splash.
Transcore followed that.
Transcore followed that judgment. No, your lordship may kindly see how they are proceeding. Only just for your lordship.
Tell us whether the list lies.
Man,
Forget about the direction for one. You are benefited that the court has said 1 crore you deposit.
the earlier order of the court, yes, minutes. The earlier
That has
order,
not been complied.
the earlier order of the court, minutes. Why that is so many? I have already paid 1 crore 5 lakhs. How can I'm running away or say? It was we had applied for a loan of more than 6 crores. They did not release the entire amount. They released only 37 lakhs for building a hotel. Time 37%. I'm sorry, 37%.
Cash, cash credit.
I tell you, Lordship, how? But they released 37% of the total loan asked for. Now, my lords, I was shortchanged. So therefore, my lords, I had to complete my hotel project. My lords, I was running a racing against time. So I had to take a lot of hand loans. And I completed the hotel project. Even though the bank did not fully furnish me, I have already my 40% margin money is lying with the bank. It is there, stuck with the bank. And I could not get the full aid from the bank. My lords, I had to complete it by hand loans. The hotel is now complete and running. Now the difficulty is, my lords, your lordships on 5th January 2024, your lordship directed, my lords, Honorable Single Judge, Annexure 16, my lords, the Honorable Single Judge categorically directed, my lords, see how they are proceeding, my lords. Categorically, your lordship directed that this.
You had an opportunity.
Yes.
Under section 32A.
My lord, they are not even.
Under section
Every time, my lord,
was given when it was served upon you.
My lord.
Seeing that your account has become incomplete.
My lord.
Then you could have faced that.
My lord, my predicament. Yes, I raised it. My lord.
The structuring of the loan.
My lords, they have been stonewalling.
There.
My lord, I bow down, my lords. I bow down, my lords. They have been stonewalling my efforts. Your lordship will see how they are proceeding.
Page. The mandate given under the statute to take a decision within 60 days.
Yes.
Where is that? Give me a surplusy act.
Lordship,
you had an opportunity.
My lords, they have been stonewalling all my efforts. Your lordship will kindly appreciate. Page 85. Your lordship may kindly. I bow down. I bow down. I will not join issues there. Your lordship may only appreciate how they are proceeding. Your lordship may kindly appreciate how they are proceeding. Page 85.
Sorry, not 2A, 3A.
3A.
Look at it.
I think 3.
Look at this, 3A. You had an opportunity to take all those funds for restructuring of the entire loan.
Your lordship may kindly appreciate this opportunity was given by this honorable court only. They did not, my lords, they did not care two hoots for the court's order. The court gives me till 19 that I will.
Who ordered Article 200 before the court?
My lords, I cannot live in the river and fight with the crocodile, my lords. It's like that, my lords. But it's like that.
Better make them friends.
No, that is my entire effort. If I was only praying, my entire effort is that I was only praying your lordship calls it 11th. This order, whatever your lordship intends to pass any order, lordship may kindly call it 11th. On 7th, by 7th, I know the outcome. They're making a last ditch effort, This is all, I need not,
He wanted a casting resort.
This is the third rate petition, man.
Last day.
This is the third rate petition.
You are benefited.
Yes.
He's sitting on the driver's seat, and my learned friend is grateful. So actually, we call it only on 11th. Some 11.
No order.
No order. No order. Only 11th. Lordship fix the date for 11th only.
And come satisfy the requirement.
I know.
Or section 17.
It's a slippery ground, I know it's a slippery ground, but I'll come ready, I'll whatever effort, but 11th Lordship.
Yes.
Any quantity. Grateful.
Next matter, I am for the opposite matter. Government has filed the appeal matter. This is with regard to the appointment of rehabilitation. This is of the amendment that can be disposed of.
We had been 14 days DP, but that in view of that 314 days.
What is the amendment says?
That new amendment, rehabilitation assistance.
What is serious interview now?
In view of this, the appeal will be disposed.
No, we have class taking this.
Yes, one order. And in the meantime, in view of this notification, also batch of cases have been disposed of by the Honorable Apex Court also. Several.
What is it? Of course, yes, donation has to be done. And then on merit it has to be disposed. So donation we will do. It's beneficial to him.
Your pardon, my lords. May I mention this? My lords, item number 36 that I had mentioned in the morning. My lords, I have already filed the requisites for sending it to respondent number. Your lordship will permit me.
Yes, the requisites right out of the accepted. Obviously directed to make to affect service.
Well, here the petitioner in this 36, the petitioner has already filed his objection to the limitation petition. The CMC did not accept the copy.
So he could not recover the requisites. So he says that I am out of time.
Yes.
So we in the morning say that first you go and put in the requisites. Now he says he has put in the requisites. We are accepting the delay can go on. What is the municipal council?
Yes.
May I mention
More than that.
respondent number 3 in the first writ appeal and respondent number 4 in the connected it.
Stay
36 months.
The stay is till
39.
today.
Item
Stay
39.
is till today in item 44. So it has to extend. Item 44, the government wanted to file counter. State has to file counter. They have not filed. Item 44. Aishwarya was appearing, in fact, last stage. Aishwarya Das.
The counter has been served.
No.
This 29/7, we directed this counter to be filed by 5th of August.
Great.
So today is the last day. And the interim order was directed, so we are what? What is your instruction?
After that, you were where? Parking this one.
There is the order of 27. By 5th, you have to file your counter. Is it ready or not? The file is not available. No, and extend the time for council.
Right. The entire order to consist. You'll also item number 47.
For a week from date. Is extended to the next.
Item 39, ma'am.
37. Item 37. Similar matter, the lordship has already decided the matter in a writ appeal. Similar matters have been disposed of by the Lord civil by.
37, I am there, my lord. Similar matter, I have, I wrote my copy from him given to.
Give him a copy.
Yeah.
If he agrees, then there is no agreement.
Can you also?
Item 39, ma'am. I have received the file yesterday, ma'am, for the High Court empanelment lawyer, ma'am. So I free only 7 days time. If my lord permit, I will file the workers' promise case. Item 39.
39, why it is appearing before me? It has to, there is a specific range. What is the matter about?
This one, this court manages regulation, ma'am.
This issue is taken up by another bill.
It was before this, before the Honorable Chief Justice Court. Thereafter, it has not gone to any other.
This is true.
Item 45.
Things is taking up on item matters, just like justice, justice. No, now it's in a single zone.
That is court number 1.
Court number 1. My lord, I
My lord, will permit.
Your lordships.
We will go to the portion number 1.
My lord,
May permit me to file the V numbers here, ma'am.
my lord mentioned item number 47.
Sorry. You find that the matter should be taken up.
Read this.
Item 40, your lordships. Item 40, your lordships, if this can come up on Monday, your lordships. Is that some mining matter which you were?
Yes.
Lord, item 45.
40?
45. Urgency, my lord.
Give me 15 minutes time, I can come and sit and.
I am sorry.
Who are the matter?
I pray, my lord, because I have been blacklisted. That's why I pray next week on Monday or Tuesday.
Next week.
Item 47, 2 weeks.
2 weeks.